So now today's seminar. The issue is wills and estates and recent issues in wills and estates, and the presenter is Terry Constantino, a member of the Victorian Bar and a member of Green's List. Terry's been in practice for about 14 years and now been at the bar for about 9 years. She's got a general commercial practice with an emphasis on wills and estates, insolvency, property law. Some interesting matters and significant matters that Terry's recently been involved in have been in the area of estates. She's currently junior in a matter with a large estate, $20 million, where the principal issue is executors' commission, something dear to the hearts of all executors, I guess. She's also been involved recently in matters involving commercial operations of companies now held by two deceased estates and involving a derivative actions under the Corporations Act, joint venture matters, intellectual property matters, in fact the whole range of things that a commercial practice entails, but as I said, with an emphasis on wills and estates. So I'd ask you to please join with me in welcoming Terry Constantino.
Thanks, Michael, and welcome everyone. It's very good of you to all turn up at your lunchtime, so I'll definitely make this worth your while. So as Michael mentioned, today's paper will be focusing in particular on solicitors acting as executors. I'm sure that it's a topic that's probably going to be dear to most of your hearts. If you haven't already been asked to be an executor, you will be at some stage of your practice. Most clients prefer their solicitors to be the executors of their deceased estates for obvious reasons. But there are some pitfalls and some obligations that you need to be aware of in taking up that role. I will start by saying that if you are invited to be an executor, take the time to think about it very carefully. It's quite an involved process. It involves quite a bit of responsibility. And as most of you who have probably already acted for executors in that role, you'll appreciate that it's not an easy task to realise assets, particularly where there's interstate assets involved. And it can be quite a time-consuming task. Don't be afraid to say that you can't do it. I think your clients will thank you for it in the end. So think about it very carefully before you take on that responsibility. Before I launch into my chosen topic for today, my paper, which the people that are present here today will have seen, I want to mention a noteworthy recent Court of Appeal decision which was handed down in February of this year. It was a leave application and leave was granted to the applicants. It's the matter of Caroline Wood and Alan Stephen Jack versus Ewan Bruce McLean, who is sued in his capacity as executor of the estate of Alfred Basic Jack, deceased, and Elizabeth Michaela Jack. I think from memory it was handed down in February, I think it was February 20 of this year. I personally think that this decision has some very serious consequences for interfeasibility of title as we know it today, and certainly in respect of the significance of Part 4 claims. And I'll explain, once I go through the facts, you'll appreciate why. But the facts very briefly. The applicants were two of the children of the deceased. They were not beneficiaries of the estate. It's very important to emphasise that. So they were not beneficiaries of the estate. The respondent was the executor of the estate, first respondent. Second respondent was another child of the deceased, another daughter. During Dad's lifetime, he transferred a property to the second respondent daughter. So there was an inter vivos transfer of real property from Dad to daughter. And what the applicants argued was that that transfer should be set aside on equitable grounds. Now bear in mind, they're not beneficiaries of the estate. They're seeking to set aside a transfer of real property that has been properly registered and that, according to the Transfer of Land Act, is indefeasible. In addition to making that application, and I think this is quite ingenious, the applicants made a Part 4 claim on their father's deceased estate. Now, it was the respondents, both the first and second respondents, not surprisingly, I guess, they made an application before the Associate Justice for summary judgment on the grounds that the applicants had no standing to bring the transfer of property proceedings because they had no relevant present interest in the estate, there being not beneficiaries of the estate. So that was their argument. And they further argued that the existence of a Part 4 claim didn't save the applicants from lacking standing. So the respondents were of the view that there is no standing and there can be no standing, notwithstanding a Part 4 claim on foot. The applicants argued that the Part 4 claim was essential because, as we all know, when a court is considering whether and if so how much provision is to be made from the estate, they will take into account the assets of the estate. And so the applicants contended that they had a relevant present interest in bringing in all property that could be brought in under the estate, because that would determine what, if any, provision they could be made from the estate to the applicants. So their standing was purely reliant on a Part 4 claim in existence. So the Associate Justice didn't grant the summary judgment application, so it went on appeal, and the appeal was permanently stayed. And here we are in the Court of Appeal. And the same arguments were put before Justices Mandy and Redlich of the Court of Appeal. There's no standing on the applicants to bring the claim, and there can be no standing regardless of the Part 4 claim being on foot. Now, what their honours found, they agreed with the applicant's contention that whether they were entitled to any provision from the estate, of course, depended on what assets were available in the estate. So that was unarguable. But the question, and this is what their honours, and I'll quote directly what they said, however, whether the applicants in all the circumstances have a sufficient financial or economic interest, if no other, as to support a conclusion that they have standing to bring the proceeding, was a novel question. Now, there is no cases that have been decided on that point, on that question of standing, in this context. And so their honours thought that it was certainly worth a question that was in need of further debate and discussion, and they granted leave to the applicants. Now, taken at its most drastic interpretation, what are the applicants really saying here? If the applicants are to succeed in the substantive hearing, which is yet to take place, then what we have is a situation where it would be possible for an inter vivos transfer of real property to be challenged after the death of a testator by persons who do not otherwise have a direct interest in doing that, and whose alleged claim in equity would operate to render a title duly registered under the Transfer of Land Act defeasible. So it opens up a whole can of worms, in my opinion, and it's most certainly a case that is worth watching to see what, in fact, the Court of Appeal does decide. In their decision, their honours did refer to a case of a decision of Justice Hargrave. I haven't referred to it in the paper, but it's a decision of Russo. And in Russo's case, there were mutual will agreements, and the applicants had made an application to remove an executor for conflict, and they weren't beneficiaries of the estate in that case. So the question again arose to whether they had standing to make that application. Now, Justice Hargrave found that as a result of the mutual will agreements in place, there was what he termed a floating trust that had been created, and it was that floating trust which gave the applicant standing in that case to bring the application. But Russo's case is arguably distinguishable on the facts because here we don't have mutual will agreements. So there is no floating constructive trust to be deemed, hence the importance of the question.